Welcome to John Redmann, Power of Attorney, the show that aims to empower you through knowledge of the law. I'm attorney John Redmann.
And I'm Shauna Sanford. Welcome to the show. Recent studies have shown that more than 40% of men in America will have been arrested at one time or another before turning 23. Now, you may find it very interesting to know that there is a critical period of time just after someone is arrested during which some very important decisions are going to be made and steps will be taken. Our guest today is going to discuss not only what the police and prosecution are doing during this critical initial phase, but what practical steps the person who's been arrested may want to do during that same time that could make a big difference in what happens in the case.
What should you do when you're arrested and taken to jail? Is calling a bail bondsman before you call an attorney always the best choice? What is a bail bond anyway? And what are some important basics everyone should know about bail? Why do many people wait and see if charges will be filed before getting an attorney? Why might that be a bad idea? Our guest today is criminal defense attorney Joe Marino III. He'll join us shortly to discuss these important topics and more.
He is a great attorney, has lots of information. Looking forward, excuse me, to talking to him. But John, you know very well that when someone is arrested, the first thing they want to do is they want to see their lawyer. They want to demand to see their lawyer. How does that process actually work?
Well, you know, on TV, it's kind of like standard in all the TV shows. I want my lawyer. Under Louisiana laws, and I think it's pretty consistent across the country, you're not entitled to see your lawyer until after arrest, after booking, and you're not going to be provided a lawyer until after you're formally charged in the courtroom. If you have a lawyer, if you make that phone call that you get after you're booked in the jail and ask your lawyer to come see you, or you find a lawyer to come see you, that's the first opportunity you're going to get to see a lawyer. Otherwise, the police, they're not going to stop in their tracks. They're going to continue to book you. They're going to continue to process you and bring you in. But obviously, the discussion about when that lawyer comes in, at what point, super important, and we want you to pay attention to that. God forbid anyone you know or love gets arrested.
That's
this
right.
is a good show to watch.
It is a very good show. Things happen quickly on TV. In real life, not so much. Coming up next, attorney Joe Marino talks with us here on the show about what happens when you're arrested. So stay tuned. We'll be back after this. Welcome back to the show, everyone. One of the scariest things that can happen to you or someone you know is being arrested. And then on top of that, not knowing what to do next.
Joe, thanks very much for joining us today and next week to talk about this very interesting topic.
Thank you.
All right, so as we talked about in the intro to the show, it's a critical time period right after someone gets arrested. Steps are being taken by the police, the district attorney's office, or the city attorney's office, and they're steps that, if I understand your position, ought to be taken by an attorney for the accused. Is that accurate?
Yes. I mean, the first thing you need to understand is that when you're arrested, the first critical step in the process is going to be the setting of your bond. If you have an attorney can meet with the judge prior to the bond being set, if you contact one soon enough, to try to see if we can get a reasonable bond set and or have you released on some type of signature bond.
Okay, well, that's a word that gets thrown around a lot. You hear it on TV. Some people know that the bond gets set. Why don't you put that in plain English? What is a bond? Why do bonds get set?
Bail or bond, the same, is basically a security that's going to guarantee your appearance in court. And there's different types of bonds.
They let you out of jail when you post the bond.
Correct.
And you guarantee you'll show up, or else a lot of money or what the value of that bond.
The bond can be forfeited. The different types of bonds are, the most common type of bond you see is a commercial bond. That's a bail bondsman. You're paying a bail bondsman 12% of the amount of that bond.
So if it's a $10,000 bond, you're paying your bail bondsman $1,200 that you never get back.
You don't get that back. The bail bondsman is undertaking the risk that you will appear in court or not by charging you a fee of 12% to have you released. If
you become a fugitive, for instance, and you flee the state and you don't show up for court, the bail bondsman's going to have to pay the court $10,000.
If you do not appear in court within 6 months of your initial missing of court, if the bail bondsman doesn't produce you within 6 months, then they pay that money. So they've got a window of time to go find you. That's where your bounty hunters come in.
Well, I think it's very important and very critical. I know you're going to go through all the different types of bonds there, but you mentioned bail bondsmen, and talking to you prior to the show, you were saying that bail bondsmen, if I'm saying that correctly, actually will contact the person who's been arrested.
A lot of times a family will get a call from a bail bondsman. That might be the first notice you have that your son or daughter has been arrested. A bail bondsman is calling you saying your son is in jail, his bond is set at this amount, and you need this much money for us to get him released.
And we're going to talk about whether or not that might not always be the best approach. But let's get through the other types of bonds first.
The other types of bonds, you have your commercial bond, which is your bail bondsman. You can post a property bond, which is you place a lien on your property in the amount of the bond.
So if you have a home, if you have some very valuable
sufficient equity, you can't, minus whatever you owe on a mortgage.
Okay.
You can post a cash bond, which is about the rarest form. You can actually put up the amount of money in cash or a cashier's check payable to the jail, and when the case is over, that money is given back to you. But then what I try to do, or what most criminal defense attorneys try to do, is for the offenses that it's appropriate, in the cases where it's appropriate, have someone released on a signature bond, the parent, spouse, or someone sign a bond saying that I am worth the amount of this bond and I will make sure that they appear in court. And that's generally only done through an attorney meeting with a judge.
So the person who wants to get the signature bond says, I have assets, I have real estate, I have a home that's worth this amount of money, but for now let me just promise you that, and with my signature, rather than having to go get a mortgage done or something like that.
Yeah, it's called an unsecured bond. Where a secured bond is when you have a property and a lien, but an unsecured bond is a signature bond. I'm guaranteeing your appearance in court, and then the person who signs your bond is going to get a notice every time you have a court appearance. They're going to get a notice just like the accused person is going to get a notice. Each time there's a court date set, they send a notice to the person who signed the bond and say, hey, your son has court on this day, make sure he comes.
So take us from the beginning. How do we get to the point where that bond is set?
Well, the first thing that happens after you're arrested is there's a booking process, and that takes hours and hours depending on how crowded or busy the jail is. So when you get to jail, the first thing they have to do is identify you. They're going to fingerprint you and photograph you, and then they're going to run a rap sheet on you. Because the judge who's going to set your bond has to know whether or not you have any type of, what's your prior arrest history, you have been convicted of a crime, you ever, all of those factors.
Are you on
the
probation?
booking process. Are you on probation? Are you on parole? Etc.
Now, at what point, though, do you let them know that you're going to get an attorney or you're looking for an attorney? Because they will have started questioning you or attempted to anyway.
Well, there's always a process when you're arrested where the police may want to interview you, read your rights, and ask you questions. And obviously, the best advice is you don't want to speak to the police or answer any questions without an attorney present. That's always your advice.
So the advice from the criminal defense attorney to the accused is that person who does not yet have an attorney or doesn't have an attorney there present with them is to simply say what to the police?
That I want to have an attorney present before I answer any of your questions.
And that cuts off the questioning, or should cut off the questioning?
That's the law.
They're
not allowed to go forward and ask you any questions. When I represent police officers, because I've represented police officers who have been accused of crimes, they never speak. They never answer questions without an attorney. Never.
Never.
So that's your best advice right there.
Okay.
Just do what they do.
To do what they do. Okay. All right. So we've gotten booked at this point.
Right.
And then what happens?
After you're booked, the judge who's going to set your bond is going to read what's called a probable cause affidavit, which is a short summary of the elements of the crime that you're charged with and the evidence they have against you. The judge then takes that and also looks at the other factors, which is your criminal record, and they generally set bonds according to a schedule for certain offenses.
Okay.
All right, now, just going back for a second, your advice is don't answer questions unless you're allowed to have an attorney present, but you also don't agree to do, let's say if it's a DWI, you don't agree to do field sobriety test or blow into a breathalyzer, because we want to make sure I want to be sure I'm understanding you, or do you take a position on that?
That's a really broad subject with regards to DWIs, because if you refuse to do a breathalyzer test in the state of Louisiana now, they can get a search warrant and draw your blood, and they may be taking your blood alcohol content may be coming into court.
So that's for another show, for another time.
Right.
But just not answering questions.
In general, you want to have an attorney present to advise you whether or not it's in your best interest to answer the questions, or simply to be a witness to the questioning and your answers.
Okay. All right, now you said that the bonds are set according to a schedule. What does that mean?
The judge or the commissioner in Jefferson Parish basically has a schedule of bonds for certain offenses. For possession of cocaine without a criminal record, the bond may be $5,000. Okay. Different offenses, depending on how serious they are and what the penalties are, they go up. And it's like a starting point. But if you have an attorney at the beginning of the process, your attorney can meet with the judge before the bond is set to talk to the judge, because the bond is supposed to be to guarantee your appearance in court. Well, a lot of times when I'm meeting with the judge before the person's bond is set, I'm telling them about background about the person, because they're not going to get that from the police report or from a rap sheet. I'm going to tell them what are their ties to the community, whether they have a college education, whether they have family members that live here. Or evidence or lack of evidence in the case that is not necessarily going to be shown in the police report.
Well, I'm sorry, just because I want to get to this question in this segment, because we talked about it in the beginning. All right, so how does all this, what you do, play into the question of whether or not or when a bail bondsman needs to be involved?
Right. I would always say that you want to contact the attorney first, because you may not need to pay a bail bondsman to get your son or daughter released from jail. And I've had many people come into my office to say, well, I'd like to hire an attorney right now, but we just spent $3,000 paying a bail bondsman to get someone out of jail that they didn't necessarily have to spend.
You might have been able to save them that $3,000.
Save them that money.
Well, someone who's never gone through that process before certainly would not know that. That's why I think the show is so very, very helpful. If a person is arrested, a loved one, a son, a daughter is arrested, and they are contacted by a bail bondsman, which more than likely will happen, they don't have to go that route.
No, that's only one option.
Can people who are considering hiring a criminal defense attorney, when they contact criminal defense attorneys such as yourself, talk to you for let's say an initial consultation before having to write a check or pay?
I mean, it varies by attorneys. I don't charge people. I don't know whether the practice is yes or no. I mean, I think in general, the criminal defense attorneys that I know will meet with you and without charging you a fee.
And then you'll decide what the fee is at that time.
Right.
Yeah, but how do you know what sort of attorney to look for, and where do you go? We'll let you answer that question as soon as we come back from the break. We have to take a quick break right now, but when we come back, we'll get to your questions, and we'll hear more from our guests, so stay tuned. We'll be right back. Hello, everyone, and welcome back to the show. Well, all week long, we've been getting your questions about arrests and what happens during that whole process. Attorney Joe Marino III is our guest today, and we're going to get right to your questions. Right before we do, though, Joe, we went into that last break talking about how to find a lawyer, what sort of an attorney you should look for. What's your advice?
Right. I mean, when you're looking for an attorney when someone's been arrested, you obviously want to have a criminal defense attorney or someone that that's the primary focus of their practice in that area, in that jurisdiction. Because I'm not going to be able to help you with any child custody questions, and if you called me about it, I would quickly tell you that. Same thing if you need a will, don't call me. So, I mean, you want to look for somebody that's in court on a regular basis dealing with people that are accused of crimes. Yeah,
and let me add to that, Shauna. I'm sure most attorneys who focus their practice in special areas of law will tell you the very same thing. In other words, somebody calls me, I don't try to help them with a criminal case. I'll recommend them to Joe Marino, I'll recommend them to other attorneys who I'm familiar with, but I'll also tell them how to do research online on how to get client ratings, ratings by peers, and there's plenty of good information out there. But definitely go to somebody who doesn't attempt to be a jack of all trades and master of none. Go to somebody who does that area of law, tries cases, and that is, I think, what allows you to be an authority in your field, and why we invite you on the show.
And we want to make clear that the information you're giving us is specific to Jefferson Parish, right? Different rules apply in different jurisdictions,
Right,
is that
every
correct?
different parish, every different location, they handle the bond process differently, the setting of the bond, all of that is different from Jefferson, Orleans, St. Tammany, Plaquemines, all different.
Yeah.
I mean, my practice is in Jefferson, so I can answer all the questions you have about
yeah, the
that.
information is generally valid, but obviously your specific case outside of Jefferson Parish, but in Louisiana, it's kind of maybe a guideline, but obviously you want to talk to somebody, an attorney, a criminal attorney in those different parishes if you have a specific question. God forbid you've gotten arrested, but call an attorney in that parish who you've investigated online or you found out has good references.
Right. Okay, let's get to our viewer questions. And we were talking about the different types of bonds that are available. And our first question is about a signature bond. And the question is, can someone be released on a signature bond for any kind of crime?
Yeah. And the answer to that is no. Generally, any crimes of violence, you're not allowed to be, the law does not allow you to be released on a signature bond. Any offenses involving distribution of a controlled substance or possession with intent to distribute, you're not allowed.
Controlled substance, we're talking about
any drugs.
Bad drugs.
Possession offenses, yes. Distribution offenses, no.
Okay, all right. And we got a question from our producer who says, does that include marijuana, drug charges?
Right.
Yeah.
The law specifically states that you are not to be allowed to be released on a signature bond or a personal surety bond for possession with intent to distribute or distribution of any controlled substance, including marijuana.
Well, one of the things that we didn't discuss, what if you don't uphold your end of the bargain, if you don't show up for court? You have a bond, what happens in the different types of bonds that there are if you don't show up?
Well, with any and all of them, when you have a notice to appear in court and you don't appear, they're going to send a notice to the surety and tell them that this person was supposed to be here in this court and they did not appear. If it's a commercial bond, they're going to notify the bail bondsman.
Okay.
If it's a personal surety bond, they're going to notify the parent or whoever signed the bond and tell them your son or daughter did not appear in court. And you have 6 months to produce them back into court. And if you do not, then you owe the amount of that bond to the parish.
You have to pay that.
You owe it, and you'll pay it. And if it's and your bond is forfeited, and that's why you see the bounty hunters are out looking for people. That's the bail bondsman. That's people that they hire to go locate people so they don't wind up paying that bond.
Okay. Our next question says, what is the difference between the bail amount and the premium?
I mean, the only thing I can assume what they're asking in that is if your bond amount is $10,000, the premium may be the percentage you pay to a bail bondsman, the 12%.
Okay, the 12%.
Right.
All right. And how long does the entire bail bond process typically take?
The bond process, from when you're arrested, the booking process is the first part. And again, depending on how busy the jail is, that could take an hour, that could take 5 hours, that could take 6 hours. And then you have to have your bond set. And if you've missed a time when the bonds are set, then the next scheduled time when the bonds are set will be the first time you'll be before the judge. I mean, you could be in jail for 24 hours before your bond is set.
24 hours.
Yes.
So this is a process. I mean, it can take several hours.
Always takes several. Even after your bond is set and a judge allows, say the judge calls into the jail and says this person can be released on a signature of his father. That process takes time as well. Because there's paperwork process, the jail has to get to it. I mean, unfortunately, it is a very slow-moving train.
Well, I know you've had this call late at night, parents calling saying, my son has been arrested and they're wanting to do anything and everything they can to get their kid out of jail.
Right.
But the chance of that happening at night, probably very slim to none, right?
Right, because if you're arrested late at night, again, you have to remember, you have to go through the booking process first, and that's several hours all by itself. So you're not going to be released, and you're not even going to be ready to have a bond set until the morning. And I'm not going to call a judge and wake them up in the middle of the night, even if you've been booked, because you can wait until the morning, into a reasonable hour, and contact the judge.
Contact the judge, yeah. So we were talking about finding a criminal defense attorney if you're in this sort of situation. And we have a question here that says, how much does a criminal defense attorney typically cost?
Right. It's generally a flat fee, again, and it depends on what the crime is. You know, I mean, an attorney set different fees, different rates. A felony criminal offense could easily start at $3,500 to represent you, depending on which offense it is, and go up.
And just so we're clear for our viewers, a flat fee means you pay one price and that attorney sticks with you.
Entire representation until the case ends. Some attorneys set an additional fee in their contract for if the case actually proceeds to trial, but only a small percentage of cases proceed to trial anyway. But I don't do anything like that. I have a flat fee, and if we go to trial, then it winds up probably costing me time and money that it's not costing my client.
We'll talk a little bit more in detail about why someone would come to an attorney versus a bail bondsman. I mean, there are certain differences there in terms of how the case is handled.
Well, the critical part about the attorney is after you're arrested and your bond is set, one, an attorney can probably save you some money instead of giving it to a bail bondsman and getting your son or daughter out. But then there's the time period between when you're actually arrested and when the DA's office is screening or reviewing the charges.
Okay.
And during that time period, you don't have an appointed attorney is not given to you at any point during this process until the DA actually files charges against you.
And that could take some time.
It could take a month.
It could take a month before the charges are actually filed.
Correct.
And we talked about this before. You don't get an attorney appointed to you for free unless you qualify. You need to be
At arraignment, which is after the DA's already filed the charges. But while you're sitting in jail, you have no attorney appointed to represent you.
And if you make a lot of money and a good paying job, you're not going to qualify for a state appointed attorney.
Correct.
Is that correct?
Yeah, they have a schedule that
Yeah.
you can only make a certain amount of money and then you don't qualify for a public defender.
Well, at what point is the arraignment date set? So you've been arrested, you've been booked, and you're waiting to be formally charged, but at what point is that arraignment date set?
It's different depending on whether you're released on bond or whether you're still in jail. Okay, if you're still in jail, as soon as the district attorney's office in Jefferson Parish files the charges, you'll be brought into court within a day or two at the most and arraigned and found, the court's going to ask you, do you have an attorney? Can you afford an attorney? This is what you're charged with, and we're going to enter a plea of not guilty. And this is your next court date in front of this judge.
Okay.
But when you're released from bond, okay, if you post bond, commercial bond or any form of bond, when you post bond, they give you a date, which is a status date, which is generally 30 or 45 days from when you get out, to appear back in court for the judge to see, well, has the district attorney reviewed your charges? Have charges been filed? Or are you going to have to come back again while that process still goes on? But what I didn't get to is when you have a private attorney, the private attorney can be meeting with the district attorney before the charges are filed to present any evidence or any facts that they need to know that are favorable to you, that the person who doesn't have the attorney, they don't have that advantage. Because if I can get the charges refused before they're ever filed, that's a much easier process than waiting till they file charges and go into court and try to get the district.
Refused, reduced, explain the differences there.
Refused are when they don't file any charges against you. Reduced is if you're charged with a certain crime, we may say, well, that's not possession with intent to distribute, that's simple possession. There's a difference in those two crimes with drugs.
So you reduce it from a more serious crime to a less serious crime.
If you can convince the district attorney that that's the appropriate charge or that that's what should be done in this case.
And so if you are successful in, let's say, getting a charge refused, is that the end of it? That client walks away, no longer has any dealings with the court system? Is that how it works?
You still have that one court appearance. If you've been released on bond and the charges are going to be refused, you'll still have that one court date to show up and appear in court, and then the district attorney on the record will say this case is not being prosecuted. That's the end of your bond obligation, and you finish. With a property bond, when they put a lien on your home, you have to go back and file to have that lien removed when a case ends, whether it ends by a plea of guilty later in the case or charges being dropped. You have to go back and do something else. Property bonds are very, very complicated, and not a lot of people do them.
Okay, well, believe it or not, we've come to the end of this first show. Thank you so very much. That is all the time that we have for this episode. But don't worry, because the conversation continues next week when we return for part 2 of our coverage of arrests. What happened? So be sure to join us again.
Thanks so much to Attorney Joe Marino III, and thanks to all of you for watching. Remember to send in your questions via Facebook, Twitter, and email, and go to johnredmondpoa.com to watch past episodes and get more information. Thanks, and we'll see you next week on John Redmann, Power of Attorney.